now the Supreme Court is looking at presidential immunity, which means it's a protection for presidents so that they can actually operate without being afraid of being prosecuted, persecuted, and attacked when they come out of office. But what has happened? He's been prosecuted, persecuted, and attacked, and they're ignoring presidential immunity. So finally, the Supreme Court is taking it up on January 6th case and going to look at it really hard and say, look, we have no business attacking somebody who was within his scope of presidency, who has come in, was doing his job, was protecting the elections, was doing the things that a president should do. Instead, they call him an insurrectionist because they can't beat him in the polls.
So by now we know with all of the criminal cases against Donald Trump, he doesn't argue that I didn't do it. What he argues is I can do anything I want to, that I'm immune from getting prosecuted for engaging in criminal conduct. That's his argument when he's talking about absolute presidential immunity, which he's asserted in the Washington, D.C. criminal case. And you hear Alina Habba right there, that's Donald Trump's lawyer, saying that she believes that he has absolute presidential immunity because he needs to be protecting the elections. And I want to explain to you why Alina Habba's argument is so utterly flawed right there. But you don't have to take my word for it. You can take the word of the 11th Circuit Court of Appeals, which just issued a decision in a case involving Mark Meadows, which, although it doesn't have to do with absolute presidential immunity, one of the reasons why the 11th Circuit Court of Appeals rejected Mark Meadows' attempt to try to get the Georgia state criminal RICO case against him removed to federal court. Remember, that was rejected by the federal judge and remanded back to state court. Meadows appealed. It went before a three-judge panel, and this three-judge panel, which included one George W. Bush appointed judge, one Obama appointed judge, and one Biden appointed judge, said, look, this removal statute does not apply to former federal officials, but even if it did, Mark Meadows, your conduct that you were engaging in that's alleged in this RICO criminal case involves elections. It involves campaigning. That's not what you are supposed to be doing as the chief of staff. That's not what you are supposed to be doing as someone who's part of the executive branch. There's something called the Hatch Act. There's supposed to be a separation between the functions of government officials, and then that's supposed to be separated from when you're engaging in campaign and election activity, which is handled outside of the office, outside of the White House, and you're not entitled to the same types of immunities and things that would attend to official responsibilities. Now, even though the Mark Meadows ruling that just came out, and it was a scathing one by the 11th Circuit Court of Appeals, does not involve absolute presidential immunity, it is consistent with a new line of cases and precedent that is being established because of Donald Trump's criminal conduct. And the main case on this, and by now all of the legal AF watchers and those who watch the MeidasTouch podcast and our shows here on YouTube on a regular basis, are familiar with the Blassingame v. Trump case, decided in the past 2.5 weeks or so. The Blassingame case involves civil lawsuits for monetary damages filed against Donald Trump regarding his conduct during the January 6th insurrection and relating to the January 6th insurrection. Donald Trump in these civil lawsuits tried to assert absolute presidential immunity, and there, not the 11th Circuit because it's in D.C. So the D.C. Circuit Court of Appeals said, look, Donald Trump, your conduct falls outside of the outer perimeter of absolute presidential immunity as it relates to the insurrection, as it relates to January 6th, as it relates to your efforts to overturn the results of the 2020 election, because it involved election activity, campaigning. Those are not Article 2 executive functions. So the cases which establish absolute presidential immunity, like the case from the early 80s, Nixon v. Fitzgerald, decided by the United States Supreme Court, that still dealt with functions of the presidency, of Article 2, whereas you engaging in campaigning and election activity falls outside of that. So you take that body of case law, and then you also have what federal judge Tanya Chutkin ruled, because She ruled against Donald Trump on an independent basis outside of the Blasingame logic, but I think all of this will now go before the D.C. Circuit Court of Appeals and the United States Supreme Court, and they're going to be bolstered by also not just what the D.C. Circuit Court of Appeals ruled, but also seeing what their sister circuit court and the 11th Circuit Court of Appeals just ruled in a slightly different context, but still this consistency of election campaigning is outside the functions of Article 2 in the executive function. But federal judge Tanya Chutkan said there is no such thing as absolute presidential immunity when it comes to criminal conduct of former presidents. It would make no sense if the United States Constitution's text and history and structure supported absolute immunity of criminal conduct. Criminal conduct is not within any outer perimeter. It's criminal in nature, and therefore you're not entitled to absolute presidential immunity. So I'm bringing all this up because these are key issues right now, and they all are inextricably related now at this point. So remember, the D.C. Circuit Court of Appeals has granted expedited briefing of Donald Trump's appeal of the federal judge in D.C., Judge Tanya Chutkan's denial of Donald Trump's motion to dismiss on absolute immunity grounds. So they're hearing briefing. Briefing will conclude January 2nd. So super expedited there. Meanwhile, we'll be hearing from the United States Supreme Court soon about whether or not they'll accept certiorari or oral argument on Donald Trump's absolute presidential immunity claim. They've ordered Donald Trump to submit his brief by December 20th, and the Supreme Court should be ruling about whether they will hear oral argument. That's called certiorari, whether they'll hear certiorari or oral argument soon. But now we're seeing all of these kind of sister courts addressing this issue, and it should be noted that Alina Habba, the great constitutional scholar you saw at the outset of the video, saying that election activity should be subject to presidential immunity, she directly undercuts what the holding is of Blasingame. But then again, she hasn't really read Blasingame, or at least when she gave oral argument or when she participated in oral argument last week in the case before the Second Circuit Court of Appeals on an unrelated matter, she was asked a question, and this was the case, just so you know what this is even about, this was a case where Michael Cohen was appealing a district court granting a motion to dismiss his constitutional claims against Trump and the United States government for remanding him into solitary confinement back in 2020 when he put out a book. There's a whole separate legal doctrine there governing that case. But one of the things Alina Habba raised was absolute presidential immunity. So the Second Circuit Court of Appeals asked her, okay, have you heard Blasingame? How does Blasingame, which states that Donald Trump doesn't have absolute presidential immunity in election and campaigning activity, apply here? She didn't know what Blasingame was. So here, play this clip.
Okay, are you familiar with Blasingame versus Trump, the D.C. Circuit case that was recent?
Let me see if it's in mine. Not off the top of my head, Your Honor.
Okay, they got this issue before we did, and obviously it is not binding authority on us, but it is persuasive, and I was hoping that you could react to it, but you don't have any reaction to it at this time.
I don't, but I can say that if it's not from the Supreme Court, and the Supreme Court has made very clear that we are not to extend Bivens unless it passes the two-factor test. My colleague,
right? That's a official act case. It's more dealing with the immunity.
Okay.
But if you're not prepared.
I'm happy to talk about the immunity in official acts.
Yeah, so she doesn't know the key case, and now you can take Blasingame and the Meadows case. I now read those cases together because, you know, this decision that was just reached in the Meadows Fulton County case, where Mark Meadows tried to remove the case. He tried to remove the case by saying that there's a federal removal statute for officers who work for the federal government. And if he can show that, one, he's an officer, two, basically working pursuant to the color of his authority as an officer, and three, that he has valid federal defenses to charges against him, he could remove the case to federal court. Well, the federal judge there in Georgia rejected that. So then he appealed to this three-judge panel. And take a look at what this three-judge panel ruled. Now, different context. This isn't absolute presidential immunity, but we have another Circuit Court of Appeals now basically saying, no, election and campaigning activity is not within the power of what the executive office should be doing or what the presidency should be doing. Here is what it says. It says, the White House Chief of Staff has no role in supervising state elections. Meadows concedes that the Constitution does not spell out a role for the president in the operation of state voting procedures in federal elections. The Constitution empowers only the states and Congress to regulate the conduct of federal elections. As the Supreme Court has explained, the framers of the Constitution intended the states to keep for themselves, as provided in the 10th Amendment, the power to regulate elections, citing a recent Supreme Court case, Shelby County v. Holder, 2013. And by the way, if you follow the MeidasTouch network, you'll know Shelby was actually a very bad decision for Voting Rights Act. It gutted the pre-clearance requirement within the Voting Rights Act and created a lot of the problems we have today. But here, Shelby stands for the proposition that states have a lot of authority when it comes to elections, not the presidency. This goes on to say the states are responsible for enacting a complete code for elections, including regulations relating to prevention of fraud and corrupt practices and counting of votes. Meadows asserts that the White House Chief of Staff has duties related to the supervision of state elections and campaign related to political activity. In particular, he maintains that broad authority and few limitations can be found in the Election Clause and the Take Care Clause of the Constitutions and various election statutes and the Hatch Act. But the district court concluded, and we agree, that the federal executive has limited authority to superintend the state's administration of elections. Neither the Constitution nor statutory law nor precedent prescribe any role for the White House Chief of Staff, and even if some authority supported a role for the Chief of Staff in supervising state administration of elections, that role does not include influencing which candidates prevail. After all, the office of the president has no preference for who occupies it. And now look what they're citing here. Thompson v. Trump, the district court case of 2022, citing with authority the other district court judges, like federal judge Tanya Chutkin's holdings, that Donald Trump is trying to act like a king. And we don't have kings in the United States of America. Donald Trump is not the president. So you see here, and by the way, Judge Pryor, who's on this panel, George W. Bush judge. So we're talking about a right-wing judge, but we see the judicial community now coming together here and basically acknowledging and giving signs to each other about Donald Trump's behavior is not acceptable in our democracy at the highest level of Circuit Court of Appeals. That's why, sure, this opinion rejecting Mark Meadows' attempt to remove the Fulton County District Attorney criminal case to federal court and just rejecting Meadows, sure, it stands for that proposition. But as you really kind of dig into the guts of this ruling, you see that there are other messages being sent here about the authority of what the president can do in elections. Nothing. And why what Alina Habba's statement was at the outset of this video completely is admitting why there should not be absolute presidential immunity for that type of conduct right there. And so I'll leave you with this, because here's what Alina Habba said recently when she does these media interviews that she does. She says she wants this case to go directly to the Supreme Court. Let me play this for you, and then I have a comment on that. Play it.
And I believe someone had called on the Supreme Court to do this exact thing. We need the Supreme Court to step in and stop this. This has become complete mayhem. And if they don't start looking at these decisions, and as the highest court in this country, as the arbiter of law, the ultimate arbiter of the Constitution, the people that are supposed to enforce our bedrock, if they don't start doing it, which thank goodness they are, we, have some law and order hopefully soon.
Well, yeah, and what I think will be cited to the Supreme Court is a line like this from this opinion, which is that the Constitution does not spell out a role for the president in the operation of state voting procedures and in federal elections. It's very, very, very clear that there is no role for the president there. We all know that she's gaslighting there, that Donald Trump's going to try to run away from the Supreme Court, because ultimately I think the issue's very clear. I think you see the 11th Circuit saying it. You see the D.C. Circuit Court of Appeals expediting their briefing, but you see what Judge Tanya Chutkin saying. You're not above the law in the system, and there are circumscribed powers of what the presidency is, and everything else is not subject to immunity. So a bad day for Mark Meadows in, of course, losing the appeal, and that case will proceed before the Fulton County Superior Court Judge Scott McAfee now. But also, when you see what that panel's doing, it's very consistent with what the 11th Circuit saying. Different context of removal versus assertion of absolute presidential immunity, but the recognized powers of the Article 2 presidency, very consistent here, and Jack Smith will have the ability to cite all of that, and he will. I know that was very much in the weeds analysis, but I hope you appreciated that one. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.